Suspended Public Protector Busisiwe Mkhwebane is expected to give evidence in her own defense when the Section 194 hearing resumes on Monday. On Wednesday, the Public Protector's Office told Parliament it will make an extra 4 million rand available for Mkhwebane's defense in her impeachment hearing. She, however, wants unlimited funds. Advocate Mkhwebane has approached the Constitutional Court to force the Public Protector's Office to supply more money to pay for her team of lawyers in February. Mkhwebane's lawyers did not appear at her Section 194 hearing because of non-payment of fees. Mkhwebane feels she should be given more funds after the Court had previously ruled that she has a right to be assisted by a legal practitioner or other expert of her choice. She says that if the money is not made available, it will be a malicious breach of the said binding court order and contempt of court. The Public Protector's Office has already spent 30 million rand on Advocate Mkhwebane's legal fees for the impeachment inquiry. The 4 million rand that has been agreed to pay for her legal team is taken from surplus funds from the 2021-2022 financial year and after getting approval from National Treasury. And joining us now to speak about this is the suspended Public Protector Advocate Busisiwe Mkhwebane. A very good evening to you, Advocate Mkhwebane. Thank you so much for speaking to us. If you could just give us a picture of, obviously, somebody who has not been through a process like this of such magnitude. This 4 million rand that is going to be extended to you by the Public Protector's Office, how far will it take you realistically in terms of your defense?
Thank you so much, Tsepiso, and to the SABC viewers and listeners. Maybe to correct you there in your opening statement saying that I'm saying the money is not sufficient. I never said that. And going to the Constitutional Court, you'd remember, Sakin, Tsepiso, that the main issue here, I mentioned that when I was told on the 1st of March that there won't be any resources for my attorneys to proceed, actually, the CEO of the office wrote to my attorneys, and then the Deputy Public Protector wrote a letter to me to inform me and that there won't be resources for us or for them to fund me going forward, and even raising issues like they don't have the resources, and copied the speaker, the chairperson of the Portfolio Committee on Justice, and the Section 194 Committee chairperson. And I think we all know that on the 31st of March, I appeared, and the chairperson then promised that they will engage, they will find some resources so that we can proceed with the matter. And on the 3rd of April, then they converted the meeting to be a committee meeting. But then they said they want the evidence leaders to empower them. And you'll remember that that's when I intervened and objected to that. But then I was muted and he didn't want me to communicate. So I received the program and the letter, which indicates that apparently there's an additional 4 million, which is availed by the Office of the Public Protector. And actually, there was a letter which I have not received, but later received from the Deputy Public Protector indicating that they've availed that 4 million. And I think that's what we will be continuing tomorrow with the process. But unfortunately, the schedule of Parliament has been attached to that. And there's no way where they are also accommodating the fact of dealing with the travesty of justice or the unlawful process of continuing for 6 days without me being present, without my attorneys, and as well the issue of the quorum or whether all the committee members were present, because when I was informed that there is money and that we are proceeding tomorrow, I'm in Cape Town now, I will go to the committee, but then the issue of the legal representation, that's what we are going to deliberate on tomorrow. But then the Constitutional Court is now getting clarity which application has been filed, the notice of motion has been filed, where we would request the Constitutional Court to give clarity as to who is supposed to pay, because the chairperson, as you'd remember, distanced himself, even saying I must go to legal aid, knowing very well what's the mandate of legal aid. The speaker distanced herself. She said she won't intervene. And what's worse is that I'm accounting to Parliament. The speaker, in terms of section 181(3) of the Constitution, is obligated to assist the public protector. And the president as well went further, saying that he can't intervene, who should be paying for legal fees and matters like that. So the matter now, as we speak, has been filed with the Constitutional Court for the Constitutional Court to allow us for direct access and as well to clarify this issue of the legal fees, which was their judgment, which said I should be represented.
So, Advocate Mkhwebane, as you've said in the past, that it is the Constitutional Court itself that says you have a right to a legal representative or expert of your choice. So when you approached the Constitutional Court, was there an amount that you were requesting be honored in terms of, or either the length of the legal process? Because as you say, you have not said you want uncapped funds, but I also still want to understand, to your mind, how much will you need that will be indicative of justice being done?
You know, Sakina, Tsepiso, sorry for calling you Sakina. Yes, it's not me to determine that. Firstly, remember what I said during at the beginning of my testimony for South Africa to know that Parliament expended or spent a lot of money in appointing the panel, the 3 panel members, Judge Nkabinde, Advocate Dumisa Ntsebeza, and Advocate Duval, to determine whether there's any prima facie case for me to answer. Indeed, surely they've been paid, those people. They did the work. They considered the motion, they considered the alleged judgments, and then they said, I've got a prima facie case to answer as far as the issue of Reserve Bank, the so-called rogue unit, the so-called the free matter, the issues of the staff-related matters, but then it was relating to only, I think, 4 officials. The Baloyi matter was not substantiated in any other. Now what happened is that on the 9th of July, or when the proceedings started, I said, I'm participating. You know, I'm not comfortable with proceeding because the matters were still before court. Participated under protest. You know what happened is that there were directives which we commented on. We were not given an opportunity to put our proposals. Now the chairperson and the committee proceeded with the Mazone motion instead of proceeding with the 3 panel members. So if we proceeded with the report of the panel, the 3 panel members would have been done by now. It's them who delayed the process. They called up to 15 witnesses who dealt with issues of CCMA. It's not me who determined that, Tsepiso. And the agreement which the Public Protector Office, the CEO, had with the attorney, Sianeho, was that the process will take 35 days. And that was based on the fact that we were going to deal with the recommendations of the panel. We never had control, or we never had any say on them then expanding this whole process and calling all those 15 to 18 witnesses who were dealing with CCMA related matters. So now the process is that the remaining period, because it was during my testimony, the schedule or the schedule which has been shared, it doesn't accommodate then the unlawful process which they dealt with, which they must still indicate how are we going to deal with that, because they went ahead, yes, with that.
Advocate, let me just then continue with that train of thought. You say the delay is on their point. You have their behalf. In the past, you have raised the issue of lack of goodwill, the lack of fairness of the process. There's been a suggestion in some quarters that you are delaying the process, that you would like to have this continue until after your term of office passes. But I'd like to know how you would feel about this. Would you feel like you have been given an opportunity to clear your name at all if this process continues until October and your term of office expires?
I indicated that, I mean, if it was the issue of me delaying the process of not wanting to clear my name, which I have started and which I indicated that I appreciate it so much, because, you know, it's a rare occasion for a Black professional in South Africa, especially when you are accused of things which you have never done, or the alleged incompetence, when you've acquired 3 clean audits, you've assisted more than 60,000 complainants and changed people's lives. So, and as well now being charged basically on what the judgments of the courts are saying, based on wrong facts. And I appreciate the process that I had an opportunity, or I have an opportunity to set the record straight. So I would want to continue indeed testifying, but remember their directives and the parliamentary rules. But the most important thing is the Constitution, which says the process should be fair, should be reasonable, and should be within time. So unfortunately, what has been transpiring in that Section 194 committee was that the process was only for concentrating on how expeditious the process should be. If you go back and calculate how many days I requested the postponements vis-a-vis what the committee, besides the fact that they are the ones who expanded the mandate of the committee, vis-a-vis the process of us continuing or them postponing because they've got other commitments, you will see that they've got more than months where they've delayed. Okay, it's months where they called unnecessary witnesses, but then additional to that is that their committee work. And that's why I would want to go back to the office as per the Constitutional Court, in fact, as per the Western Cape High Court judgment, because we've been waiting for the Constitutional Court to decide on this particular matter. How many months, so now? It's almost 6 months to 7 months, and it was an agent application. And I think the process has stretched so much. We are almost at the end, and I've started testifying. And indeed, I must still deal with CX matters, I must still deal with Friede, I must still deal with all those allegations of the disgruntled staff members. Some of them are no longer within the institution, and indeed they were dismissed based on other matters unrelated to the issues of my competence or the issues of misconduct, because it was relating to their conduct and dishonesty.
All right. Thank you so much for your time, Advocate Busisiwe Mkhwebane, the Section 194 process is expected to resume tomorrow, where she says that she's expected to testify, but she is saying that due to some of these procedural matters, it may drag on for some time.